So we've used the Newport Manual on the Law of Naval Warfare as a guide for this academy, and we're slowly working our way chapter by chapter through there. And so we're going to talk about chapter 4, areas of operations during armed conflict at sea. So just keep in mind that, as Professor von Heinig mentioned, there are some slight differences occasionally between the law of armed conflict and the law of naval warfare, where generally the law of armed conflict are rules that apply on land, also known as international humanitarian law, and these are reflected to some extent in Additional Protocol 1 of the Geneva Conventions, which makes reference to operations on land, sea, and air that affect the population on land. That will alert you that in areas of operations, anytime the naval forces are affecting the population on land, that will have some different analysis than simply naval forces fighting at sea. So there are some slight differences when the conflict can affect the civilian population on land, such as naval fires from warships or submarines that are affecting the civilian population on land, or attacks from the sea or air against military objectives on land. And the difference, of course, is that we have to understand where, you have to have situational awareness of where the conflict is occurring. Furthermore, it continues in Article 49 that there are some special rules that apply for naval bombardment of land targets and naval operations in close proximity to the coastline. This might be something like attacks against enemy warships that are tied up at the pier in a downtown area that's heavily built up and maybe with lots of civilian individuals or civilian objects that are protected. Further, let's distinguish that except for those attacks that are on land, the rules do not otherwise affect armed conflict at sea. We're going to distinguish what we just talked about, those attacks on land that can affect civilian population on land, from purely sea-to-sea engagements. One warship shooting at another enemy warship. Sea-to-air engagements, a warship shooting at enemy military aircraft. Air-to-sea engagements, military aircraft attacking surface or subsurface assets of the enemy. And military aircraft fighting against enemy military aircraft on the high seas or beyond the territory of a neutral state. So what are the differences? We will get into them in future lectures, and you'll hear from other experts, but some of them are that there's slightly different analysis on proportionality, on distinction. Professor von Heinig mentioned one of them about war, military objectives or war-sustaining objectives, and also there's a slight difference in precautions in attack. Remember, Professor von Heinig distinguished between feasible and reasonable precautions that are exercised. You'll hear that again, but just be aware that there are some slight differences when you are affecting land versus purely naval engagements. In general, if you can have just one takeaway of areas of operations, it's this central truth, which is belligerents in jus in bello are entitled to conduct belligerent naval operations everywhere in the world, everywhere, except neutral territories, neutral states, and neutral territorial seas, including, of course, internal archipelagic waters, such as of the Philippines, are inviolable. That is, they may not be an area of belligerent operations. What this means is if two states are fighting a naval conflict, they can conduct, for the most part, belligerent operations anywhere in the oceans beyond the territorial sea or territorial airspace of neutral countries. This means the high seas, the exclusive economic zones, as well as the territory, of course, of the belligerents. They can attack each other lawfully during armed conflict. That's the central theme of this lecture. So we have to know or distinguish what are the areas under the sovereignty of neutral states. And our guide for this, of course, is the law of the sea, as codified or reflected in the United Nations Convention on the Law of the Sea. So these are the areas of neutral states that would be inviolable: the territorial sea, straits used for international navigation, and archipelagic waters. Our guide then is this graphic that is reflected in the Law of the Sea and also in customary international law, which indicates that coastal states have complete sovereignty in their internal waters out to the baseline. And so they have complete sovereignty in which there is no right of entry or innocent passage, except perhaps for the exception for distress entry during peacetime. And coastal states also enjoy complete sovereignty out to the outer limit of the territorial sea, which may be as far out as 12 nautical miles. Complete sovereignty out to 12 nautical miles. Beyond this, high seas freedoms apply. And there are some other peacetime rules that apply, of course, in the exclusive economic zone, as in the Philippines, people are particularly adept at understanding for living and non-living resources of the EEZ, fisheries, as well as the continental shelf, oil and gas resources. What this means is that coastal states, especially in our case, we must be aware of neutral coastal states, have complete sovereignty out to 12 nautical miles. And this sovereignty extends on the surface of the water, through the water column. It includes the seabed and the subsoil, as well as the airspace up to the limit of outer space, which may be regarded as perhaps 100 kilometers, the Kármán line, although there's not universal agreement on where that limit might be. That division between national airspace and outer space. But if it's national airspace, it's still inviolable as part of the territory of the coastal state. Now, that doesn't mean, though, that the belligerents are forbidden from operating in the territorial sea. Belligerents still maintain their right of innocent passage during armed conflict in a territorial sea of neutral states. And you can see that there's sometimes this issue comes into the fore where there is a disagreement over what set of rules apply. Right now we're talking about the law of armed conflict and the law of naval warfare. Associated with that, the law of prize, the law of maritime neutrality, the law of blockade. All of these apply during armed conflict, but we are using this peacetime construct to inform us of where areas of operations may lawfully occur. And so there are sometimes disagreement about which one of these two bodies of law will apply. Will we apply the peacetime law of the sea, or will we apply the law of naval warfare? And that's what we see going on currently, of course, with the Russia-Ukraine conflict. Belligerents also maintain their right of transit passage through straits used for international navigation. Now, what is the difference between plain old territorial sea and straits used for international navigation? Well, the first is that neutral states or any coastal state may temporarily suspend innocent passage in the territorial sea. And innocent passage, of course, means that transit must be continuous and expeditious and not threaten the peace, good order, or security of the coastal state. Those rules also apply in straits used for international navigation. That is, one area of the high seas or EEZ, such as the Atlantic Ocean. This is the Strait of Gibraltar with Spain and Morocco. Connecting another area of the high seas or exclusive economic zone in the Mediterranean Sea. These are also territorial seas. After all, the 12-mile territorial seas of these two states are overlapped because the Strait of Gibraltar is only 8 nautical miles wide. In this special type of territorial sea that we will call an international strait, there's a different navigational regime that applies that will be have much more utility perhaps for belligerents. In these areas, rather than innocent passage, in which all states are restricted to remain on the surface, only surface transit, and show their flag, in transit passage, submarines may transit under the water and aircraft can overfly this special type of territorial sea because it's an international strait. So there's a difference in the navigational regime or set of rules that the belligerents may access. What this means is that in transit passage, there are some similarities with innocent passage. The vessels, the aircraft, the submarines shall go without delay. They cannot threaten the use of force of the coastal states, but they also are entitled to remain in the normal mode. This is the key difference between innocent passage in the territorial sea and transit passage through straits. Remember, straits are also part of the territorial sea, generally, but there's this special set of rules that is more accommodating for the international community because it allows submarines to transit in the normal mode. Unlike in innocent passage, they may be under the water. In innocent passage, in Article 20, they're required to be on the surface and show their flag. And so this might have particular relevance in naval warfare where belligerents will use neutral international straits. Furthermore, aircraft can operate in their normal mode, which is overflight. This is also different than innocent passage because there is no innocent passage for aircraft in national airspace of the territorial sea. Furthermore, normal mode includes formation flying. Other than this kind of looking cool, why would aircraft or vessels, for that matter, warships, want to transit in formation, particularly during armed conflict? Why would they want to fly like this rather than in some random order? They would do so maybe for operational reasons, for force protection, for security, and these would be allowed in transit passage. Furthermore, normal mode generally is also regarded as allowing something like refueling or underway replenishment, where you have a support ship providing, in this case, fuel to a warship. Also permitted in at least generous interpretations of transit passage would say that this is also permitted. And of course, belligerents might want to access this additional right, this navigational freedom in transit passage. Always keep in mind then that there is in the law no such thing as a gray zone. There's the law of peace, which is reflected in the Law of the Sea Convention, and there's the Law of Naval Warfare, which has some conventions and also customary law that we've already heard from. And sometimes these are confused. I would suggest, for example, in this Kerch Strait incident In November of 2018, this was confused, although scholars have disagreement. But what happened in this case is that there were some Ukrainian warships that were proceeding through the Kerch Strait, and they were attacked by a consortium of Russian forces, including Russian law enforcement elements, as well as Russian armed forces. And they were captured, and the crews were seized as well and held for a period of time. And so Ukraine took this case to the International Tribunal for the Law of the Sea, and the International Tribunal for the Law of the Sea determined that this was a peacetime activity. It was a law enforcement activity. It was a violation of freedom of navigation. But I have disagreed with this because these two states in 2018, they were already at war since 2014. And so if you look at it from the perspective of the law of naval warfare, Russia's actions would have been completely lawful. On the other hand, there was a kind of a long period of light or even periods of non-existent conflict between the two at this time, and therefore it lost, and the majority elected to view this as a peacetime situation. I would have said that the Geneva Convention, Common Article 2, means that this was an armed conflict, because an armed conflict occurs whenever there's two or more of the contracting parties, both Ukraine and Russia, are in an armed conflict, even if they don't acknowledge it. And sometimes states do not want to acknowledge that they're in an armed conflict for political reasons. So in the case, Russia was brought into this case against its will by Ukraine, and Ukraine treated this situation as a peacetime violation of its right of freedom of navigation, including seizure of its vessels and some other, it has a whole constellation of other complaints against Russia, which are still proceeding through international litigation. But in this case, it was, in the provisional measures case for Article 290, it was Ukraine asserting a right of its passage rights that were violated. So the International Tribunal for the Law of the Sea did, in fact, view this as a peacetime dispute and issued provisional measures which ordered Russia to return the captured warships as well as the detained service members. If they had viewed it under the law of armed conflict, then those service members would have a right to prisoner of war status, and of course the Russians could have kept the Ukrainian warships as a booty of war. They could have just captured them. Agree or disagree with this case, one thing that it's important to underscore is that, remember, there's no gray zone here. Refreshingly, the International Tribunal for the Law of the Sea made a decision. It applied the law of peace. I argue it probably should have applied the law of war, but nonetheless, it's one or the other. And so from a legally sophisticated view, you want to avoid this concept of gray zone. Just as an aside, even during the peacetime, Russia made a jurisdictional argument that under Article 298, Russia argued that this was peacetime, but ITLOS did not have jurisdiction because this really related to military activities. It was military activities, and parties to the Law of the Sea Convention may exercise an optional exception to remove military activities under Article 298 from mandatory dispute resolution. But nonetheless, that was a peacetime argument, and ITLOS did not accept that. It said that this was really about a law enforcement activity. Another issue that I personally would disagree with ITLOS, but I have to say that the votes were almost unanimous in both cases. So you have the it-loss decision there, viewing this as a peacetime event and also saying that it was not a military activity. It was more a dispute about navigation, is what it-loss said. So we're going through the areas under the sovereignty of the coastal state. Straits used for international navigation. We talked about the territorial sea. And now, in particular interest for the Philippines or Indonesia, are the legal status of archipelagic waters. Archipelagic waters are internal waters, internal to the baseline, and therefore we know that if the territorial sea is under the sovereignty of the coastal state, including the airspace and the water column and the seabed, then of course archipelagic waters would be under the sovereignty of the coastal state. And if the coastal states are neutral, then these areas, just like the territorial sea or straits, may not be areas in which the belligerents can pursue naval warfare. So these are quite vast areas, and archipelagic states have special rights or a special status. They're recognized in the Law of the Sea Convention in Part 4 as being states that are wholly or entirely composed of islands, and there is a special ratio of water to land that is between 9-to-1 and 1-to-1. 9 parts water to 1 part land, to 1 part water and 1 part land. The upshot of this rule is that in order to be an archipelagic state, you cannot just be a state that is composed of islands. Like Japan, for example, is not an archipelagic state. Why? It has too much land. It can't meet that ratio. You can also have too much water. The Seychelles or Mauritius, for example, may not have archipelagic status. Why not? Because they have way too much water. The Philippines and Indonesia and some other countries are right within this ratio of water to land, where they are entitled to draw straight baselines connecting the outermost points of the outermost islands. And within this area, they may assert and exercise sovereignty over archipelagic internal waters inside the baseline. From the baseline, they still, of course, like any other state, get a 12-mile territorial sea and a 200-mile exclusive economic zone. Neutral archipelagic waters are inviolable. They may not be used as a domain of naval warfare. Now, on the other hand, if an archipelagic state is in a conflict itself, remember, of course, that the national waters of the belligerent are susceptible to naval operations by the other belligerent. Still, even though neutral states, neutral archipelagic states have these inviolable waters, belligerents may still use them, just like ordinary territorial seas may be used by belligerents, so long, not for belligerent activities, but for mere innocent passage. Just like ordinary straits may still be used by belligerents, not to conduct naval warfare, but just for transit passage. Likewise, belligerents may exercise archipelagic sea lanes passage through neutral archipelagic states. And this includes, first or foremost, routes that have been recognized by the member states of the IMO as designated archipelagic routes, as you see here, 3 north-south routes going through Indonesia. They also may exercise archipelagic sea lanes passage through all routes normally used by the international community. And there's a strong argument by a number of states that are maritime states, especially Australia, Japan, the United States, Singapore, that this is an incomplete designation by Indonesia, and therefore that International flagged vessels and submarines and aircraft may use all routes normally used. At a minimum, that would include a east-west route through the Indonesian archipelago. The Philippines has not yet worked with the member states of the IMO, which is a convening body for the member states in London, International Maritime Organization. And so there's not a complete designation or recognition at the IMO for Philippine archipelagic sea lanes. It's still under discussion. And therefore, what that means is that there might be some disagreement on what routes are normally used or available that would cut through the Philippines. And there's just not resolution on this yet. The Philippines probably has an interest in having just like Indonesia, in having a narrower or more restrictive view of what those normal routes would be, whereas maritime powers or flag states might prefer more archipelagic sea lanes to give them more operational flexibility. This just has not played out yet. All right, so what we've talked about so far is that we understand there are some differences between warfare at sea and warfare on land, which we'll continue to talk about over the next couple of days. We've highlighted a few of them, and that we want to be sensitive that naval warfare may be conducted by belligerents anywhere beyond the territorial sea of neutral states. That is, virtually all of the ocean, except for the territorial seas or archipelagic waters and straits, is an area in which belligerents may lawfully conduct naval warfare. So that's what we'll talk about, are these areas beyond the sovereignty of the coastal state, which includes the contiguous zone overlapped by the exclusive economic zone, as well as the continental shelf. And of course, the high seas. Now, the EEZ and the extended continental shelf is not an insignificant area of the oceans. It's between 48% of the oceans is EEZ, or territorial sea. If you add in the continental shelf, it's about 54% of the oceans. So we're talking roughly half of the oceans that even though they are subject to some level of sovereign rights and jurisdiction by the coastal state, are still areas in which belligerents may lawfully conduct naval warfare. That doesn't mean, of course, that neutral states have not attempted to limit belligerent operations in their offshore areas. The United States, working with the Organization of American States in 1939, sought to do just that by preventing European belligerents. This was before the U.S. was involved in World War II. Remember, the United States entered World War II after Pearl Harbor in 1941. Up until that time, the United States was officially neutral, and the U.S. led the OAS, the Organization of American States, to purport to limit belligerent rights in areas extending 200 or 300 miles off the coast. Now, this predates the construction of the EEZ, but it reflects this coastal state impulse, particularly for neutral states, to keep conflict away from their shores. And the United States and the OAS made this Panama Declaration and purported to restrict the belligerents from this area. Of course, the belligerents ignored it, and they said the coastal state, as high-minded as it wants to be, doesn't have the authority to exclude large areas, hundreds of miles of the high seas, to belligerents. And so they largely ignored it, and then the U.S. entered the war. The modern manifestation of this idea is reflected in Rule 34 and Rule 35 of the San Remo Manual. The San Remo Manual is an influential work of scholarship, and there are some there's mainly agreement between the San Remo Manual and the Newport Manual on most issues. This is one area in which there's some disagreement. My view and the Newport Manual says that the exclusive economic zone and the continental shelf of neutral coastal states are areas in which belligerents have access to, that they may conduct naval warfare. The San Remo Manual in Article 34 doesn't entirely exclude the possibility of belligerents conducting naval warfare in the EEZ, but what it says is that the peacetime regime of the law of the sea, under Article 56, affords coastal states sovereign rights and jurisdiction over the living and non-living resources in the zone. Let's say fish and oil and gas. And that other states have to exercise due regard for those sovereign rights and jurisdiction. Not sovereignty, but sovereign rights and jurisdiction. This is a peacetime rule. The San Remo Manual, in my view incorrectly, purports to apply that during armed conflict. The reason that I think it's incorrect, and I've written a piece on this, is because it incorrectly mixes the peacetime law with the law of naval warfare. The law of naval warfare is a lex specialis regime. That means that it's a specialized regime, and in international law, the specialized regime prevails if there's a conflict over the general regime. And that these peacetime duties apply, but they cannot restrict belligerent activities in an area that's 48% of the oceans. There is not, in my view, a requirement for belligerents to add an additional consideration during the law of naval warfare for the living and non-living resources, such as something like restricting submarine sonar because it might spook whales, or refraining from laying mines because it might damage corals. These might all be admirable thoughts, but they're not a legal requirement in the law of naval warfare. You cannot adopt a peacetime treaty that restricts belligerents during an armed conflict. Furthermore, the negotiating history of the Law of the Sea Convention was that it was always envisioned as a peacetime document. It was never considered to be restricting during the law of naval warfare. Furthermore, I would argue that there's even an even more progressive view in San Remo Manual Rule 35, which in my view actually even goes beyond what's in the Law of the Sea Convention. By progressive, I mean it's aspirational and it is inaccurate as a matter of law, even in peacetime. What Rule 35 says is that belligerents must exercise due regard for the environmental rights of the coastal state in the EEZ. But this goes beyond even what the Law of the Sea Convention says. In peacetime, mind you. Even in peacetime, that's not a requirement. So what Article 56 says is that coastal states enjoy sovereign rights and jurisdiction over the living and non-living resources, and then they have limited jurisdiction over marine scientific research during peacetime, and as well as over protection of the marine environment. That's where this Rule 35 comes from. But the jurisdiction over foreign flagged vessels to protect the marine environment under the UN Convention on the Law of the Sea, purely in peacetime, is found in Article 211 of Part 12 of the Law of the Sea Convention, which allows coastal states to prescribe or write rules on vessel source pollution that reflect international standards. And then under Article 220, it allows coastal states to enforce those rules. But under Article 220, the coastal state can only enforce those rules if there's the threat or actual major environmental damage, such as an oil tanker breaking up. What this means is that even in peacetime, there is a very limited right of the coastal state to enforce its environmental rules beyond the territorial sea. So for the San Remo Manual to say, oh, but in armed conflict, you have to exercise due regard for the environmental rights, that goes even beyond what the peacetime requirement is. So I think that that's quite a major defect in that approach. So where does this leave us? The EEZ are not neutral waters. Neutral waters are the territorial sea, archipelagic waters, internal waters. Therefore, the EEZs are open to the conduct for hostilities because high seas freedoms apply under Articles 58, paragraph 1 and paragraph 2, which imports all of the high seas freedoms into the exclusive economic zone in Part 5. And belligerents can operate in the EEZ consistent with, it's not a free-for-all. They still have to discipline their operations according to military necessity, proportionality, and the other rules that you've encountered and that you'll learn about. Furthermore, in the law of the sea, there are areas that some coastal states have that are the extended or outer continental shelf. That means that some coastal states, including the Philippines, have sovereign rights and jurisdiction over the resources beyond the 200-mile EEZ. That means that the coastal state does not have sovereignty in these areas. Rather, it has exclusive rights and access to the resources. Let's think about hard minerals or oil and gas. The Philippines has this on the East Coast, and Professor Jay Batong has worked with the government to develop the Philippine claim. The United States has areas, not all of the coastline, but in some areas, the U.S. also has a natural prolongation of the continental margin where the geology and the morphology or the shape of the seabed is connected with the landmass, and therefore the coastal state has exclusive access to those resources. That also the same thing that applies in the EEZ applies on the continental shelf, which means that those peacetime rules are great as far as they go, but that does not impede military activities on the continental shelf, either in peacetime or during armed conflict. And because the surface is such an area of exposed threat, we're finding that naval warfare is going underwater and on the seabed. So this is an area that's a growth area. You're going to see more and more of it. You can see here that there is at least the assertion that the United States, working with friends and allies such as Japan, has an extensive network of undersea listening posts that apparently go all the way to the Andaman Islands. I have no idea if it's true. And also that other countries, other maritime powers, we may say Japan, Korea, Russia, China, are using the seabed to position installations and structures. For example, China is reported to have installations and structures on the U.S. continental shelf off the coast of Guam that are listening presumably for U.S. and allied submarines. These activities, in my view, are completely lawful, including this concept of an upward falling payload. This is prepositioning packages on the seabed that are the size of a giraffe, and you can put all kinds of things in this. You could put missiles, you could put drones, you could put torpedoes, and then you preposition these on the continental shelf of your enemy or of neutral states, and then you can activate them, such as through underwater sound, and then they can go to the surface, or they can release in the water column, and then it could be a munition, it could be a spy craft, it could be an underwater drone, or what have you. We're going to see more and more of these. The final thing to think about for the EEZ and the continental shelf is that there's actually very little difference in the availability of the EEZ and the continental shelf for military activities in peacetime and in armed conflict. In peacetime, military activities are permitted in the exclusive economic zone and on the continental shelf. And even these installations and structures, like upward falling payloads, are permitted in peacetime. Remember that Article 60 says that the coastal state has jurisdiction and control over all artificial islands on the EEZ and on the continental shelf. All of them in peacetime. Artificial islands. This has been raised in the South China Sea arbitration, that if those artificial islands that are newly constructed happen to be on the Philippine continental shelf, the Philippines can say, thank you very much, China. You have produced these artificial islands against Philippine consent, but nonetheless, those are now subject to Philippine jurisdiction and control. Artificial islands, though, are different. In Article 60, paragraph 1A and B differentiate the full control of the coastal state over artificial islands with the limited jurisdiction of the coastal state for installations and structures that are related to the purposes of the EEZ. What are the purposes of the EEZ? It's in Article 56, fish and oil and gas. So if an installation or structure is not related to fishing or oil and gas or marine scientific research for civilian scientists, then the coastal state does not have any jurisdiction over it. That's the theory that the United States, China, Japan, Korea, other maritime powers are utilizing or accessing to be able to operate on the seabed beyond 12 miles. So long as it's not associated with the economic purposes of the zone, they may use the continental shelf in peacetime and, of course, certainly in armed conflict. Okay, so we've talked about the areas under the sovereignty of the coastal state, the internal waters, the archipelagic waters, the territorial sea, and then we've talked about all the other areas that are either high seas or subject to high seas freedoms beyond the territorial sea. High seas freedoms applying in the EEZ and on the continental shelf and in the high seas, and belligerents may conduct operations in naval warfare in all those areas worldwide beyond 12 miles. That means that if Russia and the Ukraine have the capability and they want to conduct a naval battle in the South Atlantic in Argentina's EEZ, they are lawfully entitled to do so. In jus in bello. Has nothing to do with who started the war, with what country is responsible for the initiation of the conflict. It's about what is privileged during armed conflict. And the entire oceans, except for those areas within the territorial sea and internal waters and inland areas, are areas that they may access. Now, given that general rule, let's look at some specialized areas and how do they play into this. The first is Antarctica and the Southern Ocean. And there's a special treaty in 1959 that says under Article 1 that Antarctica is a special area in which the states may not conduct activities of a, quote, military measure. They may not take measures of a military nature. It's not a demilitarization per se, because you may have Navy or Coast Guard or other uniformed personnel like the National Oceanic and Atmospheric Administration that you would use because they have capabilities such as for marine scientific research, but it's an area that is outside of the remit for measures of a military nature. This is generally broadly viewed as somewhat of a demilitarization of Antarctica. Yet, like everything in law, it's not mathematical or necessarily black and white, because Article 6 of the treaty says that nothing in the Antarctic Treaty limits high seas freedoms. So there's a little glimmer that there might be access to the waters surrounding Antarctica, or perhaps even the continent itself. I might offer that's a minority view. The general view is that, look, Antarctica is off limits, but it's not under the sovereignty of a state, and therefore there is no territorial sea. Sorry, Australia, there's also not an exclusive economic zone. I know you've abandoned that sort of shadow claim. I know Australia has said that theoretically it might be able to make that claim if other states did at some future time. So no state is claiming an EEZ over Antarctica, and therefore these waters are subject to this Antarctic Treaty up to 60 degrees, generally accepted as 60 degrees latitude, the Southern Ocean. And the majority view is that these are areas that are off limits, although that hasn't been tested in a real conflict. There are also a number of nuclear-free zones or zones of peace. These are some of them. And the bottom line here is that, of course, states may join a treaty that pledges not to conduct either military operations, or in particular have weapons of mass destruction or nuclear weapons in a certain area anywhere in the world. And that's fine, they are entitled to do so, but of course that does not restrict the rights of non-parties to those conventions. And so these are largely regional conventions that do not have the buy-in of major military powers, not just the US, Russia, China, but also European states and others. So these nuclear weapon-free areas are commitments by the members, a small club, or could even be numerous countries, to say that they pledge not to have nuclear weapons in these areas, but of course that would not prevent France or the United Kingdom or Russia from operating in these high seas areas with nuclear weapons. There are also some other areas that are potentially regarded as zones of peace, including the Outer Space Treaty and the Seabed Treaty. These also unlike the other ones, may be regarded as having some customary authority in international law. That is, do they reflect customary norms? Arguably they do, but they have a rather limited restriction, in particular prohibiting the introduction of weapons of mass destruction. In the case of the Outer Space Treaty, weapons of mass destruction in outer space. We have one of your professors that you'll hear from later, Professor Dale Stevens, who's arguably one of the few world authorities on the law of armed conflict in outer space and the leader of the Woomera Manual. The Seabed Treaty has a similar type of restriction, but it only applies beyond the territorial sea. So, of course, coastal states could have nuclear weapons in their own territorial sea, but they've just promised not to have nuclear weapons or WMD beyond the territorial sea. And these are regarded as customary law and even binding on the major powers, such as the permanent 5 members of the Security Council. The Indian Ocean is a zone of peace. Rather ambiguous terms. It was adopted by a UN General Assembly resolution, and that is fine as a normative statement. But of course, the UN General Assembly has authority over exactly one thing. And what is that? It's not the member states, it's its budget under the optional, under the necessary expenses case. The UN General Assembly is a force of sort of normative expression, but it doesn't have jurisdiction over anything except its own budget. Now let's take just another look at airspace. We already have kind of talked about national airspace, which is coterminous with the outer extent of the territorial sea. But there is this creature called air defense identification zones, and so let's look at them for a moment. We want to distinguish between horizontal claims out to 12 miles and national airspace, including neutral airspace, extends out to 12 nautical miles. Remember, that's an area, if it's neutral airspace, over which belligerents may not enter or operate. Vertical airspace is generally regarded as the division between the atmosphere and outer space, and one of the metrics for this is often 100 kilometers, or the so-called Kármán line, although there's not necessarily universal agreement on that. Some coastal states, including the United States and some states in Northeast Asia, have adopted what are called ADIZs, or Air Defense Identification Zones. And these are sometimes misunderstood, so let's just make sure that we nail this down. This is the US and Canadian ADIZ. And what it means is that it's beyond the territorial sea, and it's an air defense identification zone over which the United States and Canada have said that aircraft that are operating in this zone that intend to enter into an airport of North America must connect with coastal state air traffic control authorities and communicate with them their intentions. It doesn't mean that this displaces the global air traffic control system under the International Civil Aviation Organization, in which the world is divided up into air traffic management areas for civil aircraft. What it means is that there is an extra requirement as a condition of port entry for aircraft intending to enter into the national airspace, because these extend hundreds of miles offshore. Now, the difference is that sometimes these are confused as areas of national airspace, but we already know national airspace only extends out to 12 miles, and therefore there is no authority by the coastal state in the case of the US and Canada, or in the case of China, Korea, Japan, Taiwan, to require aircraft not entering into the national airspace to coordinate with the coastal state under this ADIZ structure. And so you see in Northeast Asia there are even overlapping ADIZs. Now, if there's not a requirement, then what's the value? What's the value for this? Is it simply allows the coastal state to maintain sort of extra vigilance and sort aircraft between those that have, if they're entering, they've made some sort of declaration, they're communicating with air traffic controllers, and then if they have not communicated, or they're not, even civil aircraft are not required to if they're not entering into the national airspace, and especially military aircraft, it allows Japan or Korea to investigate. It allows them to understand those that are not communicating and perhaps pay particular attention or track foreign aircraft, and in particular foreign military aircraft, to see what their intentions are. China has been a late comer into this ADIZ, not to sort of want to be left behind, into the ADIZ in Northeast Asia. The only thing there, and I personally view it as probably just an inexperience and not necessarily intentional, although it's uncertain, China purports to apply theirs to all aircraft, meaning also military aircraft, which have sovereign immunity under Article 3. They're not even required to maintain contact with national air traffic controllers, let alone ADIZ authorities. And China also has threatened defensive measures for non-compliance. Remember, the only authority of the coastal state to assert jurisdiction over aircraft beyond the territorial sea, the only authority is as a condition of port entry. As a condition of port entry. It's analogous to Australia and the United States requiring vessels bound for their countries to inform maritime port authorities hundreds of miles out. It's not because Australia or the U.S. has jurisdiction out there, but rather as a condition of port entry, the U.S. and Australia have said, if you are coming into our ports, then we require that you coordinate that entry far out to sea. The same thing with aircraft and with ADIZs. Because the China ADIZ is asserted in a, let's just say, an unorthodox way, the United States has conducted freedom of navigation operations in the China ADIZ, using in particular B-52 aircraft. Why would we use B-52 aircraft? Because they're enormous and they have a huge radar signature. They're not stealthy, and it sends a blaring signal to China that the United States has not complied. Why is it not required to comply? First of all, it's a sovereign military aircraft, and second of all, it has no intention, has not declared an intention to enter into a Chinese airport, and therefore there is no authority by China to exercise ADIZ jurisdiction. So this was one of a number of freedom of navigation overflights into that ADIZ. And it's quite a complicated picture with these ADIZs in Northeast Asia. And just to finally put a point on it, sometimes the national media reports, quote, violations of the ADIZ when there may not actually be a violation. The only violation would be an aircraft intending to enter into or entering into the airport and not complying with the ADIZ requirements. But if it doesn't have that intention, there's no violation. And this mistake is made, perhaps innocently, by media in Canada, Korea, other countries that don't have, unlike you now, don't have a sophisticated understanding of what an ADIZ can and cannot do. When we talk about national airspace, this is just a relatively recent example of a violation in peacetime of national airspace, this so-called Chinese high-altitude balloon, parentheses, spy balloon, that the United States inexplicably allowed to go from Alaska to the east coast of the United States before it was shot down. Okay, and the final thing I guess I might mention with regard to aircraft is that there is also a right in national airspace for medical aircraft to overfly in the national airspace or territorial sea in case of necessity. Of course, that is kind of ambiguous. The coastal state and the belligerent might have different views on what that necessity is, but nonetheless, that's a rule that we have harvested from state practice and is reflected in the Newport Manual.